I will now convene the continuation of the March 14th board meeting. Today is March 15th. Thank you for being here in the Board of County Commissioners conference room. And today, Mr. Mokraski, we have a single item on our agenda, and I will turn over the floor to you.
Thank you, Chair. So this is in part a continuation of last week's work session that you heard from land management, and I think we're going to go a little bit deeper today. So without taking up any more time, I'll turn it over to Keir Miller, our Land Management Division Manager, and Amber Bell, our Planning Director, and they'll walk through a presentation and then have an opportunity for questions and comments from the board.
Thanks, Steve, and good morning, Commissioners. Yeah, as Steve mentioned, last week we focused primarily on a high-level overview of Land Management Division operations. This week we really wanted to dig into some of the details on the Oregon land use system that a lot of the concerns and issues that the board hears from constituents stem from the rules and regulations that come out of the statewide land use system. So with us today is Amber Bell, the County Planning Director. She's going to give us a background on the system and talk about some of the issues and implications that we have in Lane County in working through the Oregon land use system.
Thanks, Keir. Good morning, Commissioners. So today I'll be talking about the Oregon land use system in Oregon and also in county. We really appreciate the opportunity to be able to join you here this morning, and that's the Oregon land use system in Lane County. I want to just introduce myself first. I'm Amber Bell, I'm the Planning Director here for Lane County. I work in Land Management Division within Public Works. I grew up in the Pacific Northwest, in a rural area, surrounded by marine and forest resources. I think that's probably what drew me to do the work that I do. I've lived in Oregon for my adult life, and most of that time, I was thinking about it. Most of that time has been here in Lane County and the Willamette Valley. And I've worked at the county for 7.5 years now. And my husband and I call Lane County home. We're raising our children here. Being the planning director for Lane County is something I feel is a great privilege to me, and I really enjoy working to find solutions for property owners and community members of the county where we can within state law and land code. So with that, I'll dive right in. Wanted to give first a little bit of a framework of county planning in Oregon. So it's unique in comparison to county planning or planning in general in other states. Oregon is unique in that it has a very robust statewide planning program. And it's also, county planning is unique compared to city planning in Oregon. So we have the statewide planning program. And just to give a brief amount of history, that came about in 1973 when Tom McCall signed Senate Bill 100. And that called out, I'm going to quote him for a minute, he provided some testimony to the legislature where he called out the importance of preventing sagebrush subdivisions, coastal condominia, and the ravenous rampages of suburbia, the legislature. Senate Bill 100 created LCDC and charged them to craft rules to implement the statewide planning program. And then LCDC adopted the goals from about 1974 to 76. The program is generally comprised of the goals themselves, which contain guidance and requirements to local governments. And then the OARs that are adopted by LCDC also guide what local governments are required to do. In some instances, legislation also directs rulemaking. So the goals, the implementing OERs, and legislation is what make up and implement the statewide planning program. And another key part of the program is that local governments are required to adopt comprehensive plans. That's required for both cities and counties. And that consists of a map that shows plan designations, as well as a policy document that creates the policies for those plan designations. And then the policies are implemented by zoning maps, and then corresponding with those zoning map designations are zoning codes for each zone. So I won't go through all of the statewide planning program goals, there's a lot, but here are the 19 statewide planning goals. I will just highlight a handful that are particularly important for county planning. And I'll also mention that Lane County is a complex planning program in that because we have a geographic range that goes all the way to the coast, all 19 statewide planning program goals apply to Lane County. So one of the fundamental goals, it's goal 1, is citizen involvement, and that requires meaningful involvement of the public through all phases of land use processes. That's for long range projects like adopting a comprehensive plan or adopting code, or for development proposals as well. It means that members of the public can participate in certain development proposals. A lot of that is pretty prescriptive that comes from state law. There's specific noticing requirements and appeal processes. And it also talks about how those prescriptive state requirements talk about how you go about amending a plan, the manner in which decisions are made and issued, and then all the processes for local and state appeals. There's also local code that we have here for appeals and outreach. And then also part of it involves some of the key programs that are key parts of the local planning program, like having a planning commission. And so planning commission is our advisory body for planning matters. And then also very fundamental to the planning program is goal 2, which is land use planning. That requires, again, that each local government, city and county adopt a comprehensive plan, and the comprehensive plan has to meet all those statewide 19 statewide planning goals, which requires in-depth analysis and a variety of detailed studies. There's, I guess, long and short of it is there's a lot that goes into that plan development. Also requires interagency coordination. In some areas requires co-adoption. Goal 2 also includes the goal exception process, which in a nutshell is a comprehensive plan policy that doesn't comply with some of the goal requirements. It's applicable to a subject property or situations. It doesn't establish a planning or zoning policy of general applicability. It's really more specific. And there's essentially 3 different goal exception types, which I won't get into because there's a lot of criteria for each of those. And some of the individual goals have their own
more specific exceptions, like for public facilities, for example, there's some really specific ways that you can go through an exception to extend a sewer line to certain areas. Another fundamental goal for rural planning is goal 3, and then that's agricultural lands, and I'll talk about goal 4, which is forest lands, here in a minute. Sort of how I think about it in my brain is everything outside of urban growth boundaries is a resource lands until they're not. So the goal 3 and goal 4 require us to go through and identify agricultural lands based off of, for agricultural lands, it's based off of soil productivity. You look at soil classes that are necessary to permit farm and forest practices. You have to look at not only the subject property, but also adjacent or nearby lands. And generally the uses are to preserve and maintain agricultural lands for existing and future needs for agricultural products, and also to maintain forest and open space uses. And that is implemented by the agricultural rule and also ORS 215-213. So goal 4, similarly based off of soil productivity, but for capability of producing wood fiber, and that's based off of the natural resource conservation soils data. There's some allowances to use other information if that NRCS data is not available. But generally based off of the productivity for wood fiber, and uses are to protect forests, are either compatible or intended to protect forest uses. And that's implemented by, again, there's a implementing OER, it's OER 660 Division 6. And there's also specific provisions in ORS Chapter 215. Goal 5, another one of the key goals, requires programs to protect natural resources and conserve scenic, historic, and open space resources for present and future generations. To name a few of the resources, I won't go down through the list, there's quite a few, but they include riparian corridors, wetlands, wildlife habitat, cultural areas, and mineral and aggregate resources. And there is a requirement that we inventory, identify conflicts, determine the impact area, analyze consequences, and then develop the program to address the conflict and address the degree of protection. And for some of the resources, there's specific OER language that allows for what's called a safe harbor, which is a more kind of prescriptive path that you can take to adopt the resource, or there's what's called a economic, social, environmental, or end energy analysis that you would walk through for where there's not a specific safe harbor allowance, and governments can choose to take one or the other path to develop the Goal 5 program. Another goal I wanted to highlight is Goal 14, urbanization. This is a key one because it requires that a city develop an urban growth boundary. So that's something that's unique to the Oregon program. And cities can choose a couple of different paths to develop their UGB based on land need for a 20 or 14-year future, depending which process they pursue. It also gives provisions for single-family dwellings in exception areas. By that I mean like the rural residential, rural commercial zones, or excuse me, not rural commercial because that doesn't allow dwelling, but the exception areas include the rural commercial zones. So it provides some specific requirements for the rural residential zone. And then it also includes rules for and guidance for unincorporated communities. So unincorporated communities in Lane County like Blue River or Glenada or Vida. And it has specific requirements for the size of structures and types of uses that are allowed in those areas. There's 4 coastal planning goals. And I'll just give a quick overview of each of those. So Goal 16 protects values of estuaries and associated wetlands. It only allows water-dependent and related uses or uses that are non-dependent, that don't alter, reduce, or degrade resource or value. 17 is to protect, where appropriate, develop, and where appropriate, restore the resources and benefits of coastal shorelands. 18 kind of includes the same language, but for coastal beach and dune areas. And some specific requirements there are that it really limits the construction of beachfront protective shore armoring structures unless the development existed before 1977.
Is that, can I ask, it's AKA riprap, for example? Is
Yeah,
that what you're talking about?
exactly.
Thank you. Lay term.
Thank you.
Make sure I know what we're talking
It's
about.
like a Jeopardy game, and the question is.
Big bucks.
And it's prohibitive of residential, industrial, and commercial development on the beach, on active foredunes, on foredunes that are not active but are not yet stable, and on conditionally stable, interdune areas subject to flooding.
In other words, where Tom McCall is standing in his portrait in the Capitol. Gotcha.
And then erosion, grading and erosion is highly regulated. The idea being not only to protect the resources, but protect development from the hazards of beaches and dunes. And then 19 is marine resources and ecological functions, which I won't get into too much. Okay, so there's, by and large, planning procedures, there's a lot of requirements that come out of state law, as I kind of touched on regarding Goal 1. So I won't, going into quasi-judicial versus legislative, so that's the kinds of decisions that we often make are in one of those areas. And it's not on my slide, but there's often a third. So those are a ministerial action that's based off of clear and objective standards and criteria where there's no discretion involved by the approval authority. Kind of think of these often as a type 1 application or more over-the-counter types of permits. Quasi-judicial, that's a land use action or decision that's not ministerial or legislative. It does require discretion or judgment usually, or it requires more judgment. It can also include clear and objective standards sometimes. I kind of think of this as it's like we're acting as a judge, we're making a decision, and it often applies to development or land use proposal that's for a specific property. By comparison, legislative is more of an action or decision that involves creating or adopting or amending a policy or a law or a rule or map that affects a large amount of properties and not just a smaller subset of properties. The state program allows for appeals at the local level and the state level. So this is a list of the different appeal bodies that a land use decision will go to, and I'll get into the specific application types here in a second. Here in Linn County, we have a local hearings official. The Board of County Commissioners can review decisions on recommendation, and then from there, once there's a final county decision, then there's a 21-day period in which a decision can be appealed to Land Use Board of Appeals. From there, there's an appeal available to go up to the Court of Appeals. There's some decisions, if they're not land use decisions, and some specific processes that go to circuit court. And then from Court of Appeals, the next step is to go to Oregon Supreme Court. And then in Linn Code, we have Chapter 14, which is our application and appeals procedures. And that talks about type 1 through 4 processes. So I'll go through those. So the type 1 is more of our ministerial review again. It's made by the director or designee. So the code says planning director. In practicality, it's made by our land management division technicians and our planners with review and authorization in some cases. And there, for the type 1 determination, I should say, there's no decision, there's no appeal process because it's not a land use decision, it's a determination. And it can be effective immediately. Sometimes there's some conditions or things that need to be completed, but oftentimes it's effective immediately. And then it encompasses a number of different permit types, so I won't go into all those, but it can be a floodplain development permit or a property line adjustment or like an agency land use compatibility statement where we're reviewing for compatibility with zoning or things like that. Type 2, that involves more discretion or the exercise of judgment. Can also involve reviewing clear and objective standards. It's usually a quasi-judicial application. It involves, per Linn Code Chapter 14, we have a referral or notice of application process that's optional in the code, but we use it for most applications because that way applicants are able to see what comments members of the public have before we issue a decision. And then we're required by state law to issue notice of decision and to afford a 12-day appeal period. It can, and then at that point, if it is appealed, it goes to the hearings official, and then the decision's final after another 12-day appeal period. It can be elevated, meaning that it can go to a type 3 review based off of some criteria. If there's a high level of public comment or the applicant requests it, it can go straight to the hearings official. So type 3, that's more complex. Development impacts tend to be more significant. It goes to the hearings official for a public hearing and decision. There's, in addition to mailed notice, there's posted notice requirements. Again, there's a 12-day appeal period, and then appeal to LUBA is available once the final decision is issued. And then type 4, again, this is the more legislative type of application. This includes the creation, revision, broad-scale implementation of public policy or land use regulations, developing a comprehensive plan or amending a comprehensive plan. It can be quasi-judicial. There can be privately initiated plan amendment and zone change applications. We see those too. It involves more often additional public outreach beyond the minimum requirements of state law. It requires public notice in the newspaper. It involves a public hearing before the planning commission. They make a recommendation to the board, and then a board public hearing, and then ultimately the board renders the decision. This is a list of the plans in Lane County. There is the Eugene Springfield Metropolitan Area General Plan and its refinement plans. Each city, as I mentioned, are required to have their own comprehensive plan. And then Lane County, of course, we have our own comprehensive plan that applies outside of urban growth boundaries. That's the Lane County Rural Comprehensive Plan. And that within it has working papers that inform it and single or special purpose plans. And so those are like the transportation system plan, the solid waste management plan, the parks master plan, just to name a few. This shows UGBs in Lane County and rural zoning. And so you can see that a lot of the county is a dark green area, and that's zoned F1. These are the common zones in Lane County, and I know I'm running a little bit long here, so I'm going to move things quickly, but please do stop me if you have any questions. So this is a lot of the county zone F1. Also, there's the F2 zone. The main distinction between those two, they're both forest zones. One's not impacted, one's impacted. F2 allows for dwellings in accordance with state law, and the F1 zone does not it prohibits new dwellings. In the F2 zone.
Ember, a question from Commissioner Sunny?
Yes. Commissioner.
So, I hear from people that F2 is very hard to build on. Is that, so it's air quote allowable?
Yes, so I'll speak a little bit to the dwellings here and then also jump ahead a little bit. So there's essentially 3 dwellings that state law allows us to include in the forest zone. One is a template dwelling. That's the most common application that we've seen in the past. One is a large tract dwelling and one is a lot of record dwelling. A lot of record dwelling, they're very uncommon because you have to basically own the property going back since 1985, or a family member would have had to own the property since then. Large tract dwelling means that you own, I believe it's 160 contiguous acres or 200 acres in the county or adjacent county, and it's zoned for forest use. So that requires a large land holding. So we don't see a ton of those. And then template dwelling is where you look at essentially a snapshot in time and a certain level of parcelization as of 1993. And there's a number of other criteria that you would need to meet. In 2020, the state passed House Bill 2225, which added some additional criteria for template dwellings. And then I'll jump ahead here a little bit.
So they added more hoops to jump through.
There were some requirements that were added. And so then the other thing that happened is we long understood that there's this density standard in the Rural Comprehensive Plan, and we had long understood that it was folded into the zoning, and that the density standard didn't apply directly. And then in 2020, and this took us by surprise, frankly, this case came out of Land Use Board of Appeals called NMCISH. And there were 2 cases. The other one was King, but they essentially dealt with the same thing. LUBA further addressed in King that the density standard has to apply directly to new forest dwellings. that are within the big game habitat area. And in the major big game habitat area, they said that based off of ODF and W's recommendation in our working paper, that you have to have 80 acres for the parcel or tract to qualify for a dwelling. And in the peripheral area, big game area, you have to have 40 acres. And anything that's smaller than that constitutes a conflict. And then what was said is that the conflict could potentially be resolved if there's an amendment through an EC analysis to overcome the conflict, if that's adopted into the rural comprehensive plan. So we haven't seen any of those types of applications, but so for smaller properties, I guess long and short of it is it has become more challenging to develop, and we've seen less template dwellings.
It was never easy to begin with. It was always a special use permit process. It wasn't an outright allowable use. But then when this NIPCIsh decision came along, it really kind of was a game changer. And again, if you think back at that map that Amber originally showed with all of that dark green area, all the F1 zoning, our take at the county was always that we have so much F1 zoning that really prohibits all development. That's really where these big game protections are intended to occur. And then this case law kind of came down and said, no, well, actually, these F2, these impacted forest zones as well, you need to consider the density standards in those areas also.
I'm sorry, Kay, could you repeat that about F1? I heard you very clearly, but I want you to say it again. F1 is where big game...
F1, our initial understanding, and this predates both Amber and I's time at the county, was that we met that Goal 5 protection standard because we have so much area within
F1.
F1, correct.
And the F2 is case law that's determining the definition of big game habitat in F2.
It's basically saying you need to meet a certain density requirements to allow for the protection of big game.
And if you were to go back, I'm not going to ask you to go back to that map. The F1 is a dark green that covers almost all of Lane County. That's where we got lots of big game, and where people live, there's less big game. I guess people live down. Okay, good. Thank you.
What is the F1 percentage?
In Lane
Oh,
County,
it's about 88,
65%.
65 F1?
I thought it was,
it looks close to 88 to me.
Yeah, I thought it was around 80.
well, there's a percentage out there that said 65% of Lane County's covered with state and forest land, so that's where I was drawing that
Oh,
conclusion
that
from.
might
It
be
could be
federal
wrong.
forest lands, I'm not sure.
Mhm.
Forest land that we can't make money on. That's a side editorial comment.
There's
So
more
all-
land than just forest land that is in a F forest.
But all of that green is F1,
Yeah.
which allows no development. Got it.
Very much, yeah.
No new residents.
No new residential, right, thank you. Thank you for that clarification. Okay.
So forest zones allow primarily for forest use, allows farm use. Also, replacement dwellings are allowed in both zones. So even though new dwellings are restricted in the F1 zone, replacement dwellings are allowed, and they're either type 1 or type 2 use. Type 2 comes into play when someone's moving the home site outside of what we call the same site area, or if there's something that's unclear about how the dwelling existed and we have to, there's a discretion involved.
And Amber and Mr. Mokrajewski, if, I'm going to try to get us through this by noon so we can, some of us have very important personal engagements that need to be attended to, and others have, well, anyway, if we can, I'm not a hard line, but if we can, try to get there by noon.
Thanks. I'll try to wrap this up in the next few minutes.
Thanks.
So there's fire siting standards, an 80-acre water parcel size in the forest zones, the exclusive farm use zone. There are dwelling applications that can be made. And this comes from state law, there's specific criteria that apply, and they're type 2 applications. They're either allowed or conditional. Replacement dwellings, again, allowed, and then the zone is intended to primarily protect agricultural lands. The rural residential zone, of all the zones, when someone comes in to develop a dwelling, we point them to this zone if they're asking for what property to look at, because it allows for a dwelling as an outright permitted use if it's a legal lot. There's some additional uses that are allowed allowed. Usually they're conditional because of they involve more impacts, like things like a church or cemetery or golf course or something like that.
Question, Amber?
Just going back, you said if it's a legal lot, right? So that's usually where that, was it a legal lot, or how do I get it designated as a legal lot is what has to happen first, right?
Yes.
That's usually where
Yes,
the rub
usually
comes
that's
in.
one of the things that someone would need to do to develop, if the property's vacant. Or if if there was a dwelling, but it had been removed for some reason for more than a year, then they would be looking at that process, and I'll touch on that here. I won't get into too much of these other zones because I know we're limited on time, so, but I'm happy to answer any questions about them. Rural commercial and rural industrial are to allow commercial and industrial uses, generally speaking, and they were adopted to comply with statewide planning goal 14. They often require a type 2 application for a new commercial or industrial uses, but there are some exceptions for small additions or for replacing structures.
Is this, sorry.
Yeah.
Is this all relative, so rural commercial, obviously, we're not talking about residential. So for example, is this where the childcare siting, is that a rural commercial zone issue that we've been working with, Commissioner Buck, with the?
Gary may know more about this. This is where we're in Pleasant Hill,
Pleasant
we're
Hill.
having trouble with citing a childcare facility.
Right. There's different options to site childcare facilities at certain levels of development or density. It can be viewed as a home occupation in a rural residential zone, but when it kicks into a higher number of occupants, it can be required through a special use permit in the commercial zone, for example.
Thank you.
Do you ever think Tom McCall might snicker if he saw some of the things we have to interpret? Go ahead.
There's certainly a lot to it. It's grown. It's grown over time.
So these are some of our common combining zones. Those apply in addition to the base zone. A lot of it comes out of the Goal 5 requirements. I won't dive into those here, but these are some of them. I wanted to touch really briefly on the difference of kind of what a legal lot is. So it's not a tax lot. There is a difference there that's often confusing. So we explained to residents when we're talking with people at the planner on duty counter that it is distinct from a tax lot, which is only for assessment and taxation purposes. So a legal lot review is required. It usually comes up where there's a vacant property or if there's a criteria, which for rural residential lands, this language comes up that says lot or parcel in the rural residential zone and the OAR. There's other criteria where that pops up. And when that language pops up, what its meaning is that it's a lawfully established unit of land. And these are the criteria that we're looking at for that. So a legal lot is not needed if it's a platted subdivision lot and it hasn't changed configuration, if it's a platted partition parcel and it hasn't changed configuration, or if it's already gone through the legal lot review process and it hasn't changed configuration. But if it's vacant or that criteria comes up, then there is review required. If the property was created before our earliest county ordinance for land development, then, which is before 1949, then it might qualify as a type 1 review. We don't see a lot of those though, because usually the deed history is quite complex. And so we see a lot more of the type 2 legal lot applications. And what we're looking at there is, did it comply with all the applicable planning and land division regulations? Or was it created by a deed or land sales contract that predated those requirements? We talked about Nimkish and King already. I will just say here too that we're working on scheduling a work session with the board to follow up on the assignment to go to the Planning Commission to talk about the home builder's interpretation. We're working to get that follow-up work session scheduled for this spring. Forest replacement dwellings. So we were before the board in the last spring to talk about forest replacement dwellings, and there was some ambiguous language that came up for us through some land use appeal decisions, one that went all the way up to Oregon Supreme Court, that didn't have to do with the forest zone specifically, but did have to do with the EFU zone and was related to the same criteria. And so in comparing with what the legislature did with the EFU zone and also what was adopted by LCDC for wildfire recovery, it came to our attention that there's language in the forest zone that's a bit vague and doesn't specifically deal with what do you do if a dwelling has burned in a fire that's not a wildfire, which understandably, if someone's in that situation, they would want to know, how do I replace my home? And so this is something that we have discussed with customers at the counter, but our position is, we can't make a land use decision over the counter, of course, but our position is that we give a lot of weight to our past interpretations, and we have a past interpretation on the book that said if someone couldn't come in and get a permit because they had a house fire, that they can come in and get the permit later. We've approved those types of dwelling applications, and so we give serious weight to that interpretation that's on the books. And I'll say we have an application before us just now. I'm reviewing a decision where someone had this exact same situation come up, and we've drafted up an approval. So we just, long and the short of it is, we have every intention of approving those types of applications to the extent we can within criteria.
Commissioner Seneca?
Just real quick, so I had a constituent reach out, their barn had burned down, I believe it was F2, and he was saying that he couldn't rebuild because the flood map had changed or something, or it was built in a floodplain, probably more likely. Is there no sort of footprint variance or allowance for that? If there was a building there, you can't build a new, you can't rebuild what was there.
Yeah, so the way that these are FEMA rules, and so these are federal floodplain rules, and they look at whether or not a structure is substantially damaged or not. There's some thresholds for that, and the intent there is that development in the floodplain isn't good. If a structure is like substantially damaged in a flood or through other means, then you either need to meet the elevation criteria standards or you need to move it out of the floodplain. For barns, it's really hard to elevate a structure for a barn. You're talking about bringing in just, tons of fill, which you don't necessarily want to do in a floodplain, or you're looking at elevating the lowest finished floor, which doesn't make sense because you're wanting to put heavy equipment and all that sort of thing in there. So those become a real problem. We do have what's called a variance to wet flood proof a structure, where you kind of demonstrate that you're using flood resistant materials in the construction of it. But that's FEMA frowns on that, and as a result, that's a type 2 discretionary kind of decision. So yeah, in essence, it is very difficult to build a barn in a floodplain, and which is interesting because so much farmland is in the floodplain, and there are so many structures in the floodplain and dwellings. But again, these are federal FEMA rules that we're implementing.
So, for example, if you guys allowed him to build there, you said yes, it'll work, that could get appealed, correct? Or
The variance to wet floodproof to,
Yeah.
yeah.
could get appealed, and then, but at that point, you're kind of out of it, right? It would be between him and, say, Landwatch or whoever. Is that who would be in court, or who? How does that work? Who would appeal his?
Right, it would be a
variance?
neighbor or an appellant or watchdog group or something like that. Yeah, if we approved it, it would then, go through the process and they'd be arguing with the appellant. Staff would, of course, attend those hearings and provide our position and our original recommendation, but it's up to the next, LUBA or whoever.
Right. So, but the cost for us, if we allowed that variance, is it substantial or?
The cost, I'm sorry.
Yeah, like at the county level, say it gets appealed.
Mhm.
I mean, what does that cost us, I guess?
It
What do
really
we-
depends on how high up it goes. I mean, oftentimes we will, I mean, in most cases, we let the parties duke it out because it's
Right.
usually not this sort of situation where it's an individual property owner. Oftentimes, it's like a developer and a land use watchdog group, and we don't usually participate in those decisions above the county appeal process. But it's significant, I mean, the cost even at the local process, because we pay a hearings official to run the cases, and then we have staff dedicated to working those cases.
I guess my point, or my question was, what's it cost us to allow the variance? I mean, there was a footprint there was a barn. They have to duke it out. We can say,
Yeah.
well, there was a barn there, that's why we issued that permit.
Yeah, it costs us very little to issue the variance decision in terms of costs, it's just whether or not it's approvable. And one example is we have a barn, various what floodproof right now, that was built along the Mackenzie, and it was very clear that the standards were not met. That this was placed unlawfully, it was actually placed without permits before the fact, and they're trying to get the variance
It's my
after the
neighbor.
fact to remedy it. So we recommended a denial of that, but we actually sent it up to the hearings official because we elevated it to that, as Amber was mentioning, you can elevate it when you know there's a lot of community engagement and they want to, our recommendation was to deny, and the hearings official agreed with that and denied that. If that then gets appealed, it's probably in the community's interest that the county defend that decision. So that's one we might carry on with, but usually we don't.
Awesome, thank you.
And the term "duke it out" is found in 14 of the 19 goals.
Very descriptive, it works.
So
Close to that at times.
I want to just mention quickly ADUs. There was legislation and we adopted code to allow ADUs in urban growth boundaries. That happened in 2018. And then there is legislation that passed that allows counties to allow ADUs in the rural residential zone. And that's Senate Bill 391 that passed in 2021. It does, however, have a requirement that the state wildfire risk maps be adopted, which happened last June. And we had moved through the Planning Commission and had a recommendation on draft code that we were all set to bring before the board in the fall. However, the state wildfire risk maps were withdrawn in August. And so we're kind of in waiting mode now until the wildfire risk maps are readopted by the state, which I understand is not anticipated. I think it's until the end of this year is the date was moved again recently. And so we're tracking that, and we'll bring that back to the board as soon as we can. There is a bill in the works that I understand just passed the Senate that would decouple the wildfire risk map requirement in Senate Bill 762 from the ADU bill. And so that, if that moves forward, there may be some changes to standards that we have to take back to the Planning Commission, but we have every intention of moving forward and bringing it back to the board as soon as possible.
Question trigger.
Thank you for that. The requirement that you can't have more than one ADU, it's a 2-acre parcel, right? You can't have a smaller than 2-acre parcel to build an ADU. Is where, if anywhere, is there an opportunity to reduce that lot size restriction? Does that live, that's separate from the wildfire maps being adopted? Basically, is there any hope of us working toward a resolution that allows for smaller lot sizes to qualify for rural ADUs than 2 acres?
So in the bill, in Senate Bill 391, there is not, because it allows local jurisdictions to adopt regulations that are more restrictive than state law, but not, we can't be less restrictive. However, I understand there's some legislative interest in, it could change through the 2023 legislative session.
Do you have, this might be too speculative to be worth the time, but is that to remove that preemption or to define the lot size, the restriction?
My understanding is there's been some discussion, so I would really defer to Alex Kyler on this question. But I understand there have been some discussions of proposing potentially down to a 1 acre requirement.
Both. It's still staying prescriptive rather than just removing the preemption. Okay, thank you.
But there, I'm trying to find, I saw it. Yeah, SB 644.
Okay, thanks, Amber, go ahead.
So there's a number of criteria that we have to meet with Senate Bill 391. They may change in this legislative session, and we'll track that. But we know that we have direction from the board to adopt as clear and objective standards as possible, and that's what we work to do. And like I say, we'll return to the board as soon as possible when the wildfire risk map issue is resolved. This slide had a little bit of information about Senate Bill 644, and just that, again, that would decouple, and it includes some requirement for complying with section R327 of the Oregon Residential Structural Specialty Code, and that's a fire hardening requirements, if I understand correctly. And apologies, the slide is slightly outdated because I just learned this morning that it had passed the Senate.
2 acre.
Maybe it was HB 2749.
It probably passed while we kept you all waiting.
So I apologize. I know this has gone long, and I have 2 more slides, so I can give a brief overview of agritourism if that's helpful. And then, was that questions essentially?
Let's cover agritourism later, or do you want to do it now? Okay, we had questions, so let's go ahead. Go ahead with the slides, as prescribed.
Thank you. So agritourism, there's some options. Again, it comes pretty much directly out of state law. There is an outdoor other gathering provisions, and that is where there's an event that is a gathering of fewer than 3,000 persons. It's not anticipated to continue for more than 120 hours within a 3-month period. So it's one event every 90 days, and it's less than 1,000 persons, and that's a permitted use. If it is more than 1,000 persons, then it's still permitted use, but it requires an assembly license per lane code. And if it's more than 3,000 persons, that's not anticipated to continue for more than 120 hours, and is primarily held in open spaces, not in any permanent structures. That's an allowed use, and it's type 2, I believe. And then if it's more than 120 hours and more than 3,000 persons, then it requires a type 3 review. I believe that goes to the Planning Commission. And in the EFU zone, there's a handful of things that someone could pursue for agritourism. There's a farm stand use, that's a type 1 use. That has some limitations though, because incidental sales are limited at not more than 25%. And process items are okay, but they can't be prepared menu items. One can apply for a type 2 commercial activity in conjunction with a farm use. That does have fairly rigorous criteria as well. So it's really services and products for farm use that enhances the local agricultural community, primarily provides services for farm operations. And then there's an agritourism specific use that someone could apply for. It's a type 2 application, and that can go up to 18 events in the year. And we have seen, I believe, one of those applications. So not a lot, but there is that use that's available. And then there's a winery, cider business, and brewery uses that the state adopted. Almost all of those are type 1 uses, and with the exception of winery, because there's larger wineries that are allowed that have more uses that can be applied for. for. That's a type 2 process for things like a restaurant. And these are really, when I say large, they're wineries that produce more than 150 gallons of wine per year and have like 50-acre vineyards. So they're the larger vineyards. Another option is home occupation, though that, my apologies, but that's primarily indoors. So we don't typically see, when you think of agritourism, we don't typically see that as a home occupation application, but it is an option that someone can apply for if they want to have a commercial activity along with having a farm on their property. And because these uses are pretty limited, there was a farm cafe bill concept that was introduced 4 years ago now, I believe. And that would have allowed for sort of a restaurant concept where it's using ingredients that come from the local agricultural area. And so that's something that Lane County was involved with. And then this is just a list of our long-range projects to give you a sense of our long-range work program. We have about 2.5 long-range FTE and a number of projects in the works. One of those I wanted to highlight is the legislative and housekeeping updates. We will be tuned into anything that's related to childcare facilities or residential provisions that comes out of the 2023 legislative session, and also looking back to prior sessions and trying to figure out, if that's something that we bring forward sooner and then go back and do the full update, or whether we're able to bring it all to you at one time, but we will be being especially attuned to those issues.
Okay. Chair Farr stepped out for a minute and asked me to chair the meeting, so we have 7 minutes left if we're going to end at noon. Any questions? I don't.
Just a quick one. You
Commissioner
said the,
Hall?
thank you, Vice Chair. You said the farm cafe bill was introduced 4 years ago. And did I hear that right? That would have allowed local area restaurants to use local food? And so that's not a thing we're doing now? We have no way of doing that thing now? I'll make sure I understood that right.
Yes, it's not current law. It didn't move forward in the 2019 legislative session, so it's not current law. So if someone wanted to have like a farm-to-table dinner or offer food service or have some sort of event, it would have to operate within one of those existing frameworks.
So in order for us to change that or move that needle somewhere, we would have to have Alex and his dog sick that on the state legislature basically and reopen that. Okay.
And what I hear it got picked back up and it's being changed.
Yeah, it's a conversation that's alive in the legislature,
still?
but whether
Okay.
there is a realistic chance of it moving out of a committee is the question. There's still some pretty intense counter-lobbying forces at work.
Is that something
It's
we
not
as a-
us. It's not
Yeah.
us that doesn't want to see it passed. We
So is
have
that
been
something we as a
lobbying
board can
support of it.
help?
It's on our legislative priorities.
Is
I don't
it?
know if it is this session, because I don't know that there's no active
Yeah.
bill introduced on it this session.
But it is ongoing because it is such an issue in Lane County, being
Yeah,
a big
no doubt.
county as we are. But that being said, the composition of the legislature, as long as it's been in the composition that it's in, has kept some things from moving forward.
So that concluded my presentation. I'm happy to answer
Okay.
any other questions.
Well, then, let's go into questions, and I'd hoped and expected that we could have more time for questions, but perhaps written questions if we're kind of firm on noonish to adjourn this meeting. But you've given us a lot of information. There are 19 goals. Goal 10, my question was always around Goal 10, which is housing, which really only kind of really pertains to inside of urban growth boundaries in cities, but it really doesn't, But if you look at the language in Goal 10, the thing, and pardon me for hogging the mic for this particular moment in time, but, Goal 10 states, where is it? Well, I lost it. Focused on shaking money loose, that's not it, is it? An adequate housing supply is, this is the first language in Goal 10. An adequate housing supply is a fundamental building block of a healthy community. We're not doing it. That's all I say about that. We're not doing it. So, questions from the board?
We started that when you exited, but
Oh,
no.
well, then why don't you continue until adjournment?
We were talking about the Farm Cafe bill.
Go ahead. Then with no further questions from the board, thank you for the presentation. You know, having a close relationship with board members, I think, is essential. And I think with meetings like this allow us to feel free to call you directly without going through the director and without going through any channels, that we have your number. And you are very wide open. Congratulations on your body of work helping you ascend to your current position. Very good. I think you've worked at Lane County for close to 8 years. And as far as I know, that's about the only place you've really worked in your entire career, but you live here, you work here, you breathe it, you are it. And you are exactly the type of employee, the type of staff member and teammate that really helps us achieve our goals. So thank you.
Thank you, Chair Park. I really appreciate the opportunity today to talk about things.
Thank you, Andrew. Bravo. Ms. Mokraxi, anything further?
No, thank you.
It says other business. I see no other business. So with that, we are adjourned until 9 a.m. Tuesday morning.